me professionally going through and explaining the answers, the questions, why the answers are the answers, why they're the wrong answers are the wrong answers, and so on and so forth, to be able to give much more of a rounded learning experience versus just a static test. So here's a little bit of that. Let's go through like 10 questions, and I want to kind of show you how we're going to do it. Question number 1. In Massachusetts, a landlord has a legal right to do which of the following? Is it letter A, charge a late fee when rent is more than 1 day late? Letter B, charge a late fee when rent is more than 7 days late? Letter C, begin the eviction process once rent is more than 1 day late? Letter D, charge a late fee when rent is more than 7 days late, but not begin the eviction process until rent is more than 30 days late. Question number 1. In Massachusetts, a landlord has a legal right to do which of the following? And the answer is letter C, begin the eviction process once rent is more than 1 day late. Okay, landlord-tenant rules and regulations, definitely some stuff we want to learn and refresh as we're going to exam day. We want to make sure we remember a couple things. Now, this number 1 is very important. You want to know sort of the basic rules for landlord-tenant. Things like, what can a landlord for residential property collect up front? You learned in our courses, first month's rent, last month's rent, security deposit. Security cannot exceed 1 month's rent here in this particular state. And the bona fide key and lock rekeying of the locks. And those are the fees that we can collect up front as a landlord. Now, outside of that, we want to remember when and what happens when the rent is late. So here in Massachusetts, the landlord can begin the eviction process if you're a day late. They can start with the notice to quit or the notice of default, and they kind of move from there. So if you're a day late on rent, the landlord can begin the eviction process. They cannot charge a late fee when rent is a day late. They can start charging late fees after rent is more than 30 days late. And a charge for late fee when rent is more than 7 days, that's just incorrect. A is incorrect. And D, charge a late fee when the rent is more than 7 days, but not late, and begin the eviction process until rent is more than 30 days. So this is not correct either. Letter C all day long. This is an excellent Massachusetts landlord-tenant question. Question number 2, failure to meet which of the following requirements would result in an applicant's denial of real estate license? Letter A, passing the licensing exam within 1 year of education certification. Letter B, having a clean driving record. Letter C, having a valid Massachusetts driver's license. Letter D, demonstration of good moral character. Question number 2, failure to meet which of the following requirements could result in an applicant's denial of real estate license? And the answer is letter D, demonstration of good moral character. Okay, part of the licensing requirements here in the Commonwealth of Massachusetts is that an applicant have good moral character. One of the ways we do this, or attest to this fact, is we get 3 moral character references, of which they know the applicant but are not directly related to them and are not a part of the course and only met them through the real estate courses. Beyond that, if they know them, they don't have to live in the state of Massachusetts, but they do have to vouch for this applicant and say that the applicant who is known to them has a good history and reputation of good moral character, and if the real estate board, ever needs to reach out to them, that they could, then the applicant's moral character references are going to complete that moral character reference form, and that's that. So, failure to simply meet that demonstration of good moral character could result in an applicant's denial of a real estate license. The other ones here, passing the licensing examination within 1 year of the educational certification, you actually have to do it within 2 years of receiving your educational certification. So A is just an incorrect statement. B, having a clean driving record doesn't have anything to do with getting real estate licensed. Having a valid Massachusetts driver's license, again, not a particular requirement for licensure. And D is, for sure, a good one. Moral character references. Definitely review all of those elements that you need to know to become licensed, both for salespersons and for brokers. Question number 3. What is the main purpose of the land court here in Massachusetts, by the way? So question number 3, what is the main purpose of the land court? Letter A, to store property records, including deeds, titles, and liens. Letter B, to resolve disputes involving the ownership of personal property. Letter C, to resolve disputes involving the ownership of real property. Letter D, to oversee the licensing and practice of professional engineers and land surveyors. Question number 3, what is the main purpose of the land court? And the answer is letter C, to resolve disputes involving the ownership of real property. Okay. So here in the Commonwealth of Massachusetts, all of our public records are stored at a location called the Registry of Deeds. Now, the Registry of Deeds is by county, not city. Classic. You see many practice questions talking about that, trying to trip you up on this versus that. It's County Registry of Deeds. And basically, we've been storing records here in Massachusetts since the 1600s. And things like titles, liens, encumbrances, those types of things are all stored in public records and can be identified, and we can give actual notice and constructive notice of these various items. And that's where they are. Now, there are 2 booths when you go into a registry. Booth number 1 is going to be recorded transactions, recording a deed, these types of things, recording a mortgage, okay? And then there's a land court or a registered land section. And all y'all need to know really about registered land in the land court is the point of land court here in Massachusetts is to resolve disputes involving real property, not personal property ownership, real property ownership. To resolve disputes involving the ownership of personal property is the exact opposite, so B is out. We're in a real property class, so that's what we're focusing on, real property versus personal property. Letter A, to store property records, including deeds, title, and liens. Well, the registry handles that part of the land court's operations, the Registry of Deeds, and the land court itself is there to resolve disputes of real property. And letter D here, why it's wrong, is to oversee the licensing and practice of professional engineers and land surveyors. Well, that has everything to do with their board of overseers. So that has nothing to do with the land court specifically. Things are submitted into land court based off of the professional opinions of engineers and land surveyors, and then the land court makes determination based on various things. However, they're not there to oversee the licensing and practice of those particular professionals. Question number 4. The purpose of MGL Chapter 93A is to, letter A, facilitate the efforts of environmental cleanup of contaminated land. Letter B, prohibit the use of unfair and deceptive practices in the conduct of business. Letter C, make it unlawful to discriminate against home buyers and renters based on belonging to any of the protected classes. Letter D, to create equal opportunity for state employment for all persons. Question number 4. The purpose of MGL Chapter 93A is to, and the answer is Letter B, to prohibit the use of unfair and deceptive practices in the conduct of business. Okay, a couple things here. I will absolutely stake my reputation on the fact that MGL Chapter 93A is going to be represented on a real estate examination here in Massachusetts. You're going to see it. Now, every state has consumer protection laws, and this one has a Consumer Protection Act known as MGL, which stands for Massachusetts General Law, Chapter 93A, which is also known as the Consumer Protection Act. Sometimes they might call it the Consumer Protection Act. Sometimes they might just call it MGL 93A. You need to know that they're one in the same, number one. Number two, the point of the Consumer Protection Act is to prohibit the use of unfair and deceptive acts and practices in the conduct of business. This applies to consumer and business when a business acts unfair and deceptive to a consumer, and another type of consumer outside of a human consumer is a business consumer. So this is sort of B to C and then B to B, business consumers and consumer consumers, human consumers of business services, products, goods, services here in the Commonwealth of Massachusetts. So this is all about unfair, deceptive acts and practices. It's sort of the sword and the shield that the Attorney General has been able to give to a consumer to take action on their own. So when an owner or consumer feels that they've been treated unfairly and or deceptively, that's when they can use 93A to go after it. Now, one of the big things that you do want to remember, we learned about this in my class, is that 93A does not apply to suing a seller. A buyer can sue a seller under, other tortious claims, but they cannot bring an action against a seller of real estate using 93A. They can go after their broker, but they can't go after a seller using 93A. And that's just one of the fine points that we learned about in my class. However, letter B is the correct answer all day long. An excellent, sort of introduction question to what is Mass General Law, Chapter 93A. Question number 5. In Massachusetts, an owner who loses their property to a tax sale generally has how long after the sale to reclaim the property? Letter A, 30 days. Letter B, 60 days. Letter C, 90 days. Letter D, 6 months. Question number 5. In Massachusetts, an owner who loses their property to a tax sale generally has how long after the sale to reclaim the property? And the answer is letter D, 6 months. Okay, so in courses you learn in Massachusetts, there are tax sale rules and regulations, and the 6-month thing that we learn about is the 6-month statutory right of redemption. It's a right to redeem the property 6 months after the tax sale has occurred, so long as the delinquent taxpayer can come up with the interest and penalties and the amount of back taxes that were owed to the highest bidder at the auction. Then they can keep their property within that 6-month period. After that, then the person that's the highest bidder at the auction can then request a tax sale deed here in the Commonwealth of Massachusetts. So you can pay somebody's delinquent taxes, but they have 6 months statutory right of redemption to be able to get that back balance paid up. So in some states, the day of the auction is when you lose your property. But so you learn about 2 types of redemptions. One is the equitable right of redemption, which everybody has to correct a default before the auction happens. That's called equitable right of redemption. And then after, some states like Massachusetts have a statutory period, statutory meaning by law, legislative act, period after the tax sale. And here it's 6 months. You definitely want to know they have 6 months. So in Massachusetts, an owner who loses their property to a tax sale generally has how long after the sale to reclaim the property? And the answer is D, 6 months.
Hey everybody, did you know that we offer a Massachusetts real estate course? And whether you still need to take your 40 hours, or whether you want to retake it for review, or if you just know someone that wants to get started, check us out at Host Group Real Estate Academy. I'm going to drop a link below, and we're offering a killer deal right now. I've taught thousands of students over the years, and I'd love to have you in an upcoming class.
Question number 6. Which entity oversees Title V regulations? Letter A, the Massachusetts Department of Environmental Protection. Letter B, the Massachusetts Department of Consumer Affairs. Letter C, the Massachusetts Office on Disability. Letter D, the Massachusetts Board of Real Estate Brokers and Salespersons. Question number 6, which entity oversees Title V regulations? And the answer is letter A, the Massachusetts Department of Environmental Protection, or we sometimes just call them the DEP. So Title V, for my students, you learn about it in my course. Title V is all about septic and cesspool inspections and requirements to change them, requirements for inspections, and so on. Right? So, the Title V is that here in Massachusetts. Now, who oversees that is the Department of Environmental Protection. The Mass Department of Consumer Affairs, the Mass Office on Disability, and our board, the Massachusetts Board of Real Estate Brokers and Salespersons, have nothing to do with environmental anything, right? So none of them have anything to do with it. And there's a lawsuit. The Office of Consumer Affairs might get involved with the AG's office is suing somebody on behalf, but they're utilizing this. But the sort of the sheriff, if you will, for environmental issues is the Mass Department of Environmental Protection. On the federal level, we have the EPA, and in many states, they just have them as labeled as DEP, or the Department of Environmental Protection. Pretty straightforward question, but a good one. Question number 7. In regards to security deposits for a lease, which of the following is true? Letter A, it must be returned with interest the day the lease agreement ends. Letter B, it must be returned without interest within 7 days of the end of the lease agreement. Letter C, it must be returned with interest within 30 days of the end of the lease agreement. Letter D, it must be returned without interest within 30 days of the end of the lease agreement. Question number 7. In regards to the security deposit for a lease, which of the following is true? And the answer is letter C, it must be returned with interest within 30 days of the end of the lease agreement. So here in Massachusetts, leases, residential leases. Now, let me just upfront explain that so that students, when you're studying this stuff, here in Massachusetts with landlord-tenant, all of that stuff specifically, unless otherwise noted, is going to be about residential rentals. Okay, so this is all about residential rentals. Now, here in Massachusetts, on a residential rental, the security deposit, which cannot exceed 1 month's rent, it can be less, it just can't exceed 1 month's rent, must be in an interest-bearing escrow account, number 1, here located in the Commonwealth of Massachusetts, and that interest-bearing account must hold the security money, and obviously it's accruing interest, and then within 30 days after the last day of tenancy, the security deposit with interest must be returned at the end of the lease agreement. So letter C all day long is correct. They're going to try to throw you off. They're going to throw in a different number, like 7 days here. With the day the lease agreement ends, not true. You have 30 days to do that, and then it must be returned without interest. That's incorrect, okay? So this was letter C and letter D were very similar, all right? The only difference here is with interest or without interest, and here in Massachusetts, security deposits must bear interest. Question number 8. Who is responsible for setting real estate commission rates in Massachusetts? Letter A, the Board of Real Estate Brokers and Salespersons. Letter B, MAR. Letter C, the Attorney General. Letter D, the broker and their seller. Question number 8, who is responsible for setting real estate commission rates in Massachusetts? And the answer is letter D, the broker and their seller. Okay, Classic question line that you see. You just want to know that all commissions are 100% negotiable, period. And there are no statutory limitations on what someone can charge for real estate commissions. And it's 100% negotiated between the buyer or seller and the real estate professionals. The board has nothing to do with commission disputes, as a matter of fact. MAR stands for the Massachusetts Association of Realtors. They have nothing to do with it. They do have some guidance and governance, just like NAR does, the National Association of Realtors. But they want to keep it laissez-faire, open, free, sort of negotiable, and they like it that way. And the Attorney General has nothing to do with it either. But they might intervene if there's some kind of let's say, antitrust violation or something like that. But the broker and their seller are in charge of negotiating real estate commissions. Question number 9. Which of the following is true in order for a corporation to obtain a corporate broker license? Letter A. All partners must obtain an individual broker surety bond. Letter B. At least one of the partners must hold a real estate broker license. Letter C. At least one of the partners must hold a real estate broker license, and all the other partners must have individual surety bonds. Letter D. All of the partners must first obtain a real estate broker's license. Question number 9. Which of the following is true in order for a corporation to obtain a corporate broker's license? And the answer is letter B. At least one of the partners must hold a real estate broker license. All right. So we learn in courses what it takes to get a broker's license here in the state of Massachusetts. We also learn how can an artificial entity be licensed. And you learn that basically one of the members needs to have some kind of a broker's license. And that's it. Only one of the partners must hold a real estate license. And that's primarily it. All right. Great question. Pretty simple. Good question at the end of the day. Question number 10. The Massachusetts law that was passed in 1998 to create financial incentives and liability relief to encourage the cleanup and the reuse of contaminated property is called letter A, the Brownstone Act. Letter B, the Brownfields Act. Letter C, the Massachusetts Redevelopment Act. Letter D, the Wetlands Protection Act. Question number 10. The Massachusetts law that was passed in 1998 to create financial incentives and liability relief to encourage the cleanup and reuse of contaminated property is called and the answer is letter B, the Brownfields Act. Okay, so Brownfields Revitalization Acts are definitely things that you learn about in real estate courses. You learn them on the national or federal level, and you learn them on the state levels. So here in Massachusetts, we have the Brownfields Act. It was passed in 1998. Sometimes that might be relevant, sometimes not so much so. A couple of little tricks that they gave you here is, maybe the student remembered Brown or Brownfields, but they picked A accidentally. So they sometimes will couple questions like this. The answers will be very similar. The Massachusetts Redevelopment Act does sound pretty good, but it's not the one we need. And the Wetlands Protection Act deals with wetlands preservation and what you can do and what you can and cannot build. It has nothing to do with liability relief to encourage cleanup of contaminated sites. That is the Brownfields Act. All right, so that was 10 questions. I hope you found that analysis helpful. Go through the questions, study hard, study well, and I look forward to hearing about your successes on your upcoming real estate examination.